Okay, everybody, I think we have our screen sharing taking effect. So what we're dealing with here, loved ones, is I have a petition / counterclaim starting on the left-hand side of the screen, and I will blow this up in a minute. What this is doing is just setting out the basics. But look, okay, so here's the interesting thing, loved ones. Since we announced this event happening, right, like an hour ago, where we said, okay, I'm going to go online and help Bryce with his thing, right? Okay, since that 1 hour, I sat down, I grabbed this whole court form, and I filled it out A to Z in an hour. And to be honest with you folks, it's about 90% finished. So I'll try to make this a little bigger. I think that's going to work. So again, that was just to give you a quick overview. I will leave it right on here for just a minute so that you can either take screenshots or whatever you want to do here to record this. Again, this is going to be recorded for us all for all of perpetuity's sake, so it doesn't really matter. But however, we can just talk about this for a quick second. So again, a counterclaim, right? This is your response to someone trying to sue you for something. Whatever this is, this can be for civil or criminal. But interestingly enough, right, when you're being charged criminally with something, this is where you want to come in now and deal with it civilly, believe it or not. Once you settle your civil stuff, you actually, by default, take care of the criminal stuff on the side. Now, again, we don't want to advertise the shit out of that, or we don't want that to be the primary basis as to, you know, getting bad guys out of trouble. That's not what this is about. But technically, that's how you want to defend these things properly. See, on the civil side, we can exercise all of our equities real quick. Now, they can drag us into the criminal side when we have done nothing civilly to protect ourselves. So that's the problem. So civilly, we want to start there first. That's where all the property is. That's where all the interests are hiding. So we can just go on here. So, you know, because this is an existing court file that Bryce is dealing with, he's actually going to put that court file right here. I don't even know what it is, to be honest with you. ABC 123, whatever it is. Now, I know he's down in the Kelowna, British Columbia area, so that's where he's going to be maintaining this. His surname, I'm going to suggest right here that for all intents and purposes of what's going on, I would do that. Your Honor, dear Registrar, I cannot act in person. I'm afraid to admit anything to do with that surname until this motion is dealt with. I need proper instructions from a court. And if you don't like the way I've styled that name right now because I'm trying to protect my private interests, I suggest you set me up with a quick meeting with a master or a judge so that I can hear that from him. If you allow me to continue, magistrate. Now, again, let's pretend that the registrar is throwing paperwork up and down and he or she's yelling and screaming at you, telling you no bloody way, blah, blah. Okay, fine. Stick the surname in there. Why? Because it doesn't matter. We're entering the game in person. Remember, we're already deemed to be in person. That's locked down. We don't need to fight with that a lot. So let's just roll with it. Rolling with this is going to do one of two things. Okay, we're not denying part A. Let's just go with part A. But throughout the rest of this document, as you're about to see how it quickly unfolds here, we're setting the stage to redress ourselves. So we may have showed up in costume, but by the time we're done with this, we're out of costume, Your Honor. And fundamentally so. So again, now, because I don't even know, loved ones, if Bryce's case, if this is a civil action or a criminal. But to be honest with you, it probably doesn't matter, because who's coming after Bryce on the public side is probably going to be the Crown, represented by the Attorney General in the right of the province of British Columbia. That's typically how they're going to be coming at us. Or, you know, in the States, you know, the we the people, or the state coming after Mr. Johnson. So whoever's coming after you in that other case, their name goes here. Because now, as you can see, they are the defendant. You are the plaintiff. Plaintiff sets the jurisdiction for this particular court case. We can either play by the legal rules or we can play by the equity rules. Now, they never, again, this is why they never taught us this stuff. That particular title, the plaintiff, it's his game, it's his show. If he does it right or if he does it properly, we're off to the races. So Now, again, as I was suggesting there, as representing the Queen or Her Majesty the Queen in the right of the province of, or again, that's typically how they style their proceeding when they're coming against you. All I'm saying, loved ones, is just style it exactly the same way that they were coming after you. What would you do, Darren, if I wasn't being sued or chased by the Crown or the state? How would I style that paperwork? Well, you know what? Jane Doe, John Doe actually gets the job done. I was mentioning this the other night. It literally does. If you have more experience and you want to start naming defendants, like the Attorney General's office, if you think you can hold him accountable and prove that you can, maybe attach a security interest to that office, go for it. But Jane and John Doe work just fine. When you come with an urgent notice to a judge's chambers, again, remember, urgent means you're not playing by the normal court rules and you're not bound by the normal time limitations. This is a whole other ball of wax, loved ones. There is no rules here. None. They can literally open everything up and at the judge's discretion, entertain everything you're talking about here. So that's why we can actually rip through this pretty quick, believe it or not. Once we get a few of these blocks or once we get a few of these things in line, we can have a lot of remedies thrown at us real quick. So again, to get this particular form, again, it gives us the option here, of course, to name a few other defendants if you want. Again, if you were feeling brave and you want to bring the Minister of Finance in, go for it. But again, that's a little bit more advanced. We'll let that go for now, unless people out there want to go down that rabbit hole. We can do that one too. And again, I want to thank everybody for showing up, because I can actually see why me doing this style of a Zoom meeting, real life, these documents, like I was talking about doing for the last week, 3 weeks, 2 weeks, I can actually see why this is going to be so much more advantageous for everybody, because we can eliminate a lot of questions and we can deal with a lot of stuff all in one go here. So primarily in every petition or application or anything that we're going to bring to a court to have a settlement made or an order issued or a decree declared by the court, if we were lucky, this process needs to be met with certain circumstances, a statement of claim or a statement of facts. What is it that you're got a problem with? Well, and why do you have the problem? This is, I'll just, before we get into these here, I'll just show you the other ones. So we got a statement of stuff. Then we got to go with the relief sought, as in what it is you want for remedy, or how do you want to be paid back, or what do you think is fair, type of deal. And then this thing finishes up with, okay, well, what's the legal basis for your claim? Give them something in legal land that they can all look at and they can say, oh, okay, yeah, well, according to right here, number 4, equitable relief for plaintiff under the BC Law and Equity Act. This is huge, loved ones. This is that concurrent jurisdiction I was talking about. This is where, again, I could just go down these little items here for a second or two, but you know what? Relief against penalties and forfeitures. Whoa, number 24. There's one we might be interested in at some point. Custodian of infants, surety who discharges liability is entitled to assignment of securities. Really? That, loved ones, is exactly what we're all after. That is gold. So again, I just showed you 2 or 3 type of things. Merger, under the doctrine of merger, Your Honor. There's probably, out of this list here, what have I got? 30, 40, 50, 60, almost 70 items. I bet you 30 of those. Take your pick. Vesting orders. I just saw that one. Where did I just see vesting orders? Anyway, there it is. Number 37. Assignment of debts. Oh, yeah, we'll take that. Injunction may be granted or a receiver appointed. Hey, when I'm paying my securities into court, Your Honor, can I do it under Section 39 of the Law and Equity Act, where I require an injunction so that the court may grant a receiver to receive the monies I just paid into court? Boom. It's literally that easy. So back to our little court claim case over here. We'll go back to our statement of facts. Now, they really want us to be breaking up our facts into one paragraph. They don't really like it when we take one paragraph and we fill it with 25 different facts. It just becomes harder for them to dissect it and administrate it and organize it. So really, right here, this opening line, can I make this a little bigger? Oh, I did. Ooh, too big. Hang on. Okay, well, good enough. I can read it. Okay, number 1. Petitioner is effectually disposed of a certain security interest. That is such a loaded statement right there. You could literally say, Your Honor, that just about settles it. The fact that we're disposed of an interest, remember, loved ones, that interest was attached to us at birth. We never got rid of it. We never disposed of it. Literally, take it off, put it in the garbage, or put it in the mail and send it to that proper party. Okay, so effectually disposed of. Okay, what does effectually disposed of mean? It means, hey, I took that birth certificate, I attached the coin, I appointed it new trustees, I, in good faith, delivered it or transferred it, or under a transmission, sent it to the rightful owner. That means I no longer have the thing. If I no longer have the thing, Your Honor, I can't be sued in that thing's name anymore because I don't have it. Another little factoid I should probably even fire in under, even number 2. This is how important this one is. Here, right off the top of my head, petitioner does not possess the person in which he or she is being sued. Oh, Your Honor, how can I be held liable for this thing when it's not in my possession? Doesn't make sense. We got a big confusion of things here, Your Honor. We got to settle some stuff. So, okay, so I've been disposed of a certain security interest and brings suit in his own name. That is another game changer. That's you acting in your dual capacity, right? Because in the rest of the sentence just a second ago, we literally just said, hey, I got rid of one of my personalities, and now I'm just left with this one. And this is the good one, Your Honor. So, and basically, and because I've done these 2 things and bring suit in his own name, notice his better claim for equity is shown by his private appointment of new trustees made under, let's suggest here, made under, no, wait a minute. How about, we can literally see made under or expressed. There we go. How about this? Expressed by a deed. Oh, you can even say this. Deed absolute. Now, do we want to declare that a mortgage? Nah. Let's just stick with deeds for now. So let's just say expressed by a deed absolute, comma, and made under the, I don't like doing this, but I'm going to do it anyway because the registrar is going to like it. What that just said was, hey, the Trustee Act recognizes trusts, right? That's why it's called the Trustee Act. Okay, so the thing here is, though, we got to get entitled to even create that trust. That's why I'm not entitled, or Bryce here is not entitled, until the moment he has been disposed of that dirty thing. The moment you can prove that, loved ones, is the moment you walk into equity, is the moment you literally have all the reliefs, all the bells and whistles, all the unicorns and rainbows. That's immediately when that literally happens. So I went on here in this same paragraph, but again, this little guy here, plaintiff is without adequate remedy at law. You know what? I think I actually did that. Hang on. Look, see, look at that, me being ahead of myself. Plaintiff is without adequate remedy at law, and thereupon having regard to his conflict with the rules at law. Okay, so you just established you got the conflict. And again, under the Judicature Act, 1873 to 1875, if a party has a conflict or a variance between the rules at law and the rules of equity over the same thing, then the rules of equity shall prevail. Boom, you got a claim, you got a conflict though. So, and then given consideration of the premises, that means, hey, I created a deed, I attached a coin to it, I expressed it as a trust, and that is literally a premises. That's a few big heavy points right there that literally acts as one big event that entitles you to do what it is you are asking the court to do for you. Okay, so what are we doing after we got this initial premises established? Well, initial process ought to issue. What's initial process? That's where the clerk or the master is going to take your stuff and file it. Actually honor it. Start the process. What else is included in a potential initial process? Well, believe it or not, they can grant a temporary injunction right now. Why would they grant a temporary injunction? Okay, well, what is an injunction for starters? Well, it's a legal or equitable process. Again, this is one of the remedies that's hiding at law and in equity. Equity loves injunctions, but you won't hear them use that word on the public side. Instead of the word injunction, they say this instead. Well, we're not going to grant you an injunction, but we're going to declare your title. We're going to declare your priority. Once you have your priority established, guess what? Now you can roll in and say, well, yeah, because you got your power back. But again, this is where in equity, they'll call it an injunction, but not so much on the public side. They'll only call it declaring your titles properly. That puts you in the position where you just got subrogated with the crown, and now you're technically wearing the creditor's shoes, and those guys are now wearing the debtor's shoes. That's the beautiful thing. Now, I'm going to talk about contribution up here in a second in one of my other points here, but just to finish this one. So the initial process ought to issue where his prayers, we are always praying. This is huge in equity, loved ones. When it comes to our relief, remember, this is what we're talking about here. We're talking about a statement of facts that says, hey, he ought to have the relief he prays for, or he ought to have general and alternative relief, as so heard by the court type of deal. What's the difference between special and alternative? I know we've talked about this loosely in the past. Special alternative is an injunction. It's an extraordinary remedy. And accounting is also another extraordinary remedy. Specific performance is another one. Appointment of a receiver is another one. So that's why, what's the general relief then, Darren? Well, that's all the normal stuff that we would get. You know, we're probably going to get maybe the judge's personal representative there. He's going to now take on any bills or any receipts that you've paid for in maybe the last year. Forward all of those to my assistant here for reimbursement. We're going to set up an account for you. Why? Because you paid into the court your birth certificate with the coin with specific instructions. That is an incredible special deposit. That's the deposit, and nothing else comes freaking close. Well, Darren, it's just a little piece of plastic and one silver coin. How can that be worth more than $100 million? Trust me, loved ones, when we finally understand the debt side of everything, the fictitious side of everything, and what's backing these securities, when we actually truly find out it's our life energy taken away from us through a mortgage that's funding these little certificates, that little guy instantly becomes very valuable. And they know this. That's why they want us to cash in on these things. But according to the rules of the game, if we don't play the game perfectly, if we don't submit our stuff perfectly, if we don't do it according to procedure, they're going to bounce it. And again, Dean and I have been having our stuff bounced for 10 years. So don't feel bad when the court clerk looks at you the first time and says, I can't do this. And you say, well, I guess that means I got to send it to judges' private chambers then through the registered mail to deal with my equitable matters privately. Could you please forward me that mailing address then? What's she going to do? Say no? Yeah, right. Of course she's going to forward that. So that was number 5. And again, I left this for number 5 is suggesting that, hey, you have to state that you're praying for something. So that now, okay, that's the first time you create it, or that's the first time it comes to play. And then you talk about it again in your prayers for relief. So now you've actually talked about it twice. So there's 2 witnesses going on already. Now, when it comes time to writing the order, believe it or not, you repeat it again. So now you got 3 instances talking about the same set of facts, but the set of facts slightly evolves. Once you display, or once you express, or once you nail down some facts, now you can just briefly refer to those facts. Yeah, Your Honor, remember on December 21st of 2020, that trust deed was expressed and duly executed, as indicated by this mailing receipt. Boom. There's one incredible statement of fact. That's why the mailings, again, as we're talking about the mailings here and on the chats, there's been a little bit of concern about the grantee, grantor, and stuff like that going back and forth. We can talk about that more at length. That's not an issue. But what we're actually starting to do here is show the judge, hey, if I've been disposed of a security interest, Your Honor, the judge's first question is this then. Show me the proof of your security disposition. Sir, what are you going to do? Well, Your Honor, you're in possession of the original certificated security and registered form. You got it. Now, here's the affidavit that suggests I have a deed constructed in the background here. Your Honor, it's beautiful. I spent 4 years on it. Trust me, my heart and soul's in this one. I really hope you want to see this. This is the judge coming to you now. He can't come to you if you haven't disposed of the thing, though. Remember, monsters are not allowed into chambers. They don't like them there. Okay, so before I finished 2 and 3 and 4, before I talked about 5, I know I did this in a bit of a silly order here. I would like to start a section 6 here. And this is what section 6 would technically say. Something to this effect. Petitioner reserves any and all right, liberty, or process to avail himself in the future. Did that wrong? Anyway, like respecting above, this type of thing. Again, we can polish these little guys, but you know what? Again, this is kind of it, like 9 out of 10. By you reserving your right here, this one is actually very important, loved ones. I've actually been told stories where a gentleman, he was in court for a week, and the judge was actually literally saying, wow, so-and-so, you've actually done a fantastic job presenting all your facts and doing all this and showing me this evidence and shit, like you've actually blown my socks off. But I have to award in favor of the defendant because you didn't reserve your right to continue. And he's like, are you effing kidding me, Your Honor? You made me go through court for a week, and then you finally drop that right at the very end. Right, and this guy was being led to believe he was doing such a fantastic job, he was going to win. So that's why this guy's heart was broken when he lost on something as stupid as a technicality as that. So that's why I'm always going to suggest, respecting anything that we need to amend. So this is what we technically want to be saying here. Petitioner reserves any and all right, liberty, or process to amend his affidavit or suit as necessary in order to avail himself. There. Again, look how short these things are. Are you kidding me? Again, this is what I'm saying. Like, we don't need to spend 40 freaking pages doing this stuff anymore. Okay, so what we can do here is we can cut out this one. We'll get rid of this. Get rid of that. Gone. So we can back that up. I'm not too worried about making the box smaller. Okay, so again, this is understatement of facts. What are the factual things of your case? What's the material nature? What is it that we're trying to do here? Well, initially, plaintiff quietly brings his counterclaim, or this counterclaim, by petition to apply for leave. Applying for leave is everything. If we don't leave that old military base, we are stuck. They will not let you go bring your equity into a whole new jurisdiction if you're still in the first old shitty jurisdiction. You literally got to leave that first one. Okay, so we're going to leave that first jurisdiction under urgent circumstances. Under urgent circumstances is very important. Urgent circumstances can be heard by a judge or master at chambers right now. Right now. If you were ready to go, and if you were standing in the courthouse, the clerk might literally say to you, well, do you want your hearing right now? The judge might need 15 minutes to look at your stuff beforehand, and then boom, you're literally walking into chambers. Not joking. It can literally happen that fast. So urgent, again, remember, it gets rid of the average or the normal or the public court rules. If we don't have to play by the court rules because your claim, your motion, your petition is special because it's urgent. Why is it urgent? Literally, it's a matter of life and death. I've been disposed of that interest. I can no longer act in person in good faith. Therefore, Your Honor, I can't be left just out in the naked in the wilderness now. We need this all to be wrapped up. I need to be protected. I need my equitable rights afforded to me, maintained, observed, acknowledged, acted upon. What was I talking about here? Okay. So under these urgent circumstances, to bring his suit properly on the equity side of the court, where complete redress ought to issue out of chambers, given the sensitive nature of the case. Now, this is where we would literally use this nugget. We would literally grab this and pull this into our legal. What's the legal basis of your claim? Well, because I have a conflict with the rules at law, and I know the rules of equity are going to prevail, I'm going to drop this one here first. We are actually suggesting that because of the sensitive nature of this case, boom, they are going to seal it right then and there. They have to seal your particular case from the public. Why? Because it's expressed in a trust, it's special, and you're no longer in possession of that little guy, that legal character. That's 2 or 3 big reasons why, hey, Your Honor, we got to seal this. The public's not allowed in here anymore. Now, if you want to put in here, you probably could even put motion to seal. Oops, seal. Now, do you actually file paperwork that suggests motion to seal? Like, is that a whole extra special set of documents? Or can we actually mix it into this thing that we're talking about right now? Again, you know what? For everything that we need to do right now, we can just leave it like this, motion to seal. They can read this, but they know because it's in brackets that at their discretion, they can seal, the registrar right then and there can literally seal your case. Boom. Once you're sealed, now you can get into chambers because now there's no other courts left. If you're sealed out of public, how are you going to get your remedy in a public court now? It's impossible. See, now the only alternative is to roll into chambers. That's a huge deal. So where was I going with that? Okay, so the equitable, the legal basis is, and you know what? I'm going to suggest, oh, look at that one here. Number 44 on that Law and Equity Act. If rules of equity and law conflict, equity prevails. Okay, thank you. It's a big one. Recovery of property. That's another thing that we could be talking about in this particular thing if we wanted to. Receivers and receiver managers. Oh, hang on, we got a question. Oh, the man of the hour is coming in. Well, good thing he's going to get to watch the first hour of this at his leisure. Okay, so I was just told as well that you guys do not see the right-hand side of my screen where I'm actually looking at the BC Law and Equity Act. But trust me, I'm looking at it. And when we upload this to have you actually check this out later, I think we can actually have it set up so that you can actually see the pages that I'm technically looking at. So shout out to Bryce. I know he's just joining us now. Right on, brother. So what we're going to do here for the legal basis is, let's just, okay, I'm looking at this Law and Equity Act right now. And you know what? I'm going to suggest this. Let's just drop number 4 without even going into me explaining what it is. Here's the title of it. Equitable Relief for Plaintiff. This is so dangerous just by itself. It opens the door for everything. Okay, so now I'm actually going to go to section 4 of this particular act. And again, because we're talking about law and equity here, this is a big deal. Yeah, they're bringing it up in acts and statutes, but you know what? That's okay. Why? Because we're deemed to be acting in person anyway. And look at the amount of equity here. So I'm actually going to drop now. Okay, I just went and cut and pasted section 4. So here it comes. Ready? Check this out. Let's see if I can just stretch this a little bit. Here, I'm just going to read it. If a plaintiff, I guess that's like a plaintiff who's painting something. If a plaintiff or petitioner claims to be entitled to an equitable estate, really, or right to relief on an equitable ground against a deed, oh, good thing we're talking about deeds, instrument or contract, or against any right, title, or claim asserted by a defendant or respondent in a cause or matter, or to relief founded on a legal right that before April, way long time ago, 100 and whatever, 50 years ago, could only have been given by the court as a court of equity. Oh, that sounds delicious. The court, either as a court of law or equity, and every judge of it must give the plaintiff or petitioner the relief that ought to have been given by the court in a suit or proceeding in equity for the same or similar purpose properly commenced before April 29th, 150 years ago. That is a loaded paragraph if I've ever heard one. What they're saying there is, as long as you can prove that you've got some type of equitable estate or some type of claim to equitable relief, if you can prove you no longer got the birth certificate because you did something with it, boom, you're entitled. This one, you know what? I'm actually going to just throw this at Bryce that he just actually pleads or sticks with just this one. Because this single legal basis does so much. Yeah, I could get into other ones here, like, well, here's number 7 on this same Law and Equity Act. It says judicial notice of equitable estates. Yeah, okay, well, that's a nice one. Avoidance of multiplicity of proceedings. There's another equitable remedy. Equitable waste. There's another good one. Mergers, number 12. You know what? Oh, I'm so tempted to put that one in. Let's just do it. Let's just do it. Okay, so now, before I do that, I just want to go back here and technically up here, when you're going to start quoting these acts and statutes, I would always say this. I would even put this, equitable remedy sought by petitioner in virtue. When you're virtuous, what does that mean? Equitable remedy sought by petitioner in virtue of. Now, this is where you're going to want to just drop in the title or the commencing thing here of your particular act and statute. So this one is coming at you right now. I hope this size is right. And virtue of pasting. There you go. Law and Equity Act, RSBC Chapter 253, number 4. Boom. And then it's laying out what number 4 is. So we have to establish our claim or our position by stating the facts. And then we have to talk about it again when we're talking about the relief we're praying for. And then again, now we talk about it a third time when we talk about what's the legal basis for your entire claim. Well, the first thing we want to do is get equitable relief for the plaintiff. That's why I think this is probably one of the top 2. There's another one mixed in here that would probably be just about as effective. What is it? Here, I'll just tell you right now. We just mentioned it a moment ago. I think it was 44. Nope. There you go. Number 34. I was close. Surety who discharges liability is entitled to assignment of securities. If I've ever heard of a reason to bring a motion to a judge to have your estate settled, that's it. You are the surety. You just discharged your own liability and you're entitled to the equitable relief, which is an assignment of that security to the new debtor. That's such a powerful one too. You know what? I'm actually going to leave it up to Bryce to see if he wants to throw that one in there or not. I'm confident that, you know what, that first one, that number 4, lays down enough track to seriously kick some equity door open. I'm going to suggest Bryce goes and does 34 as well. So all he's going to do is style it exactly the way I did here in his number 1 paragraph. Equitable remedies sought by petitioner in virtue of the Law and Equity Act, section 4. So do section 34 in this box. So I'll just put same as above. and then add section 34. Now, this is where it gets to be tricky. We're always, okay, where we're at now is never, ever, ever bring an equitable problem or an equitable claim and then use legal statutes to get you the remedy. That's the big nasty commingle. That's the big oil and water. That's the big no-no right there. However, because British Columbia is blessed with having a certain, like I said, a certain piece of legislation here called the Law and Equity Act. And again, loved ones, this particular document, this particular chunk of legislation, it is dynamite. So use this to get out of that concurrent or that neutral jurisdiction. We show it up in person in the legal. We just used a neutral environment with a neutral pleading with some equity overtones to get us into purely equitable stuff. But we can't jump from purely legal to purely equitable. We literally have to have a standby flight. What's that called? Where you're flying to this place and they redirect you there first, land and check your bags and all that shit, wait for 4 hours, then jump on another flight to get to where you're going. It's your connector flight. Okay, the middle jurisdiction is your connector jurisdiction. Again, this is the concurrent one. So we got straight up common law, we got straight up at law, we got straight up Caesar legal, concurrent equity, a little bit of equity, a little bit of legal in the middle. That's where we're swimming. That's the hallway that Jody was mentioning the other day. This is the tough part. Once you get through the hallway, now you're finally through the gate, and now you only use the purely equitable stuff. Why? Because the judge is going to grant you an order here declaring your perfected title, suggesting that you do have the use or a security entitlement held in trust, and that a new debtor or a new trustee is going to manage everything for you. That is how this rolls. Okay, so I'm just going to blow over this one more here, quick time, because I don't even think Bryce has seen all this. Okay, dude. So yeah, Bryce, if you just got to take snaps of this, for now, I'll just hover on these images for just a second, and then you can fill in from there. Because I think we're being told that we won't be able to have this uploaded by tomorrow. So you know what your file is, man, from that other case, whatever they were coming at you with, drop that one in here. Of course, you're at the Kelowna registry already. Now, who are you? You're the counterclaimant. You're coming as a counterclaimant against another party. You're an individual. You are not an organization. Now, I'm going to suggest, Bryce, for your surname, put private here. If they bitch and complain, stroke it out and write it in underneath in brackets in red if you have to. But start with this. As a matter of fact, let's just don't have it here as a third name. Let's just get rid of that surname. That pretty much sets the stage for who you are and what you're doing and what you're coming from. They know as soon as they see the surname is a little bit different. Again, they're either going to explode on you or they're going to let this through. Now, again, but registrar, on the air to that particular person, I'm not the person. I can't act as it anymore. That's the whole point of this court case. Okay, so who's the defendant? Well, they are an organization, Bryce. So again, so whoever is coming after you in that other matter, probably is, Her Majesty the Queen and right of the province of British Columbia as represented by the Attorney General's office. Whatever that caption is, drop that in here. Whether it's, Her Majesty the Queen and right of the province of British Columbia here, and then as represented by the Attorney General's office, break it up if you have to like that. I don't think you have any other defendants you need to name. So what we can do is we're just going to keep rolling through here. Now, I do believe what we should be including in this paperwork is they're going to want to know what your address is. Now, I think one of these things I click on, it goes to another drop-down menu somehow, some way. And that's where you can actually fill in your address and your occupation. If you want to put in there security entitlement holder, if you want to put in there vested with equitable interest, don't put I'm a carpenter from 9 to 5. Do not say anything legal here. When you admit to some type of occupation, literally you just jump back into the legal world because, again, occupation is a military war term. You got an invading force shows up at your country, now they're occupying. That's a term of aggression. We actually want to stay away from the word occupation. Okay, so then we got right into your statement of facts. Now, this is where Bryce, okay, now you can say something like this as well, Bryce, to start this statement of facts. I, Bryce, bona fide protected purchaser for value without notice, not in possession of the legal character in which I am being sued. Whereas a suit was brought against me, dated whenever that thing started against you, a year ago. So put that date in there. In the Supreme Court of British Columbia. And then you continue with this. The petitioner is effectually disposed of a certain security interest. That, as I was just mentioning before you got on here, Bryce, is a loaded statement. That is huge. Now, again, as soon as the registrar sees that, they actually have to say, okay, what security interest are you talking about? Oh, well, let me refer you, registrar, to my exhibit number 1, exhibit A1. That's where you could literally show him, her, your adverse claim, your original birth certificate with a coin on it. Remember that thing we did? Drop that right here into your first exhibit. So now the clerk is looking at the actual certificated security and registered form pursuant to a little bit of legislation. You're talking about an assignment. You're talking about a trust. You're talking about your protected interests. You're talking about vesting. So what that adverse claim was loaded. There was so much shit on it. It was unbelievable. I bet you could get away with 30% of it. But again, this is where I'd rather come in heavy and let them pick apart what it is that is not required. But what I'm going to suggest is, hey, come in with a little extra. It's easy, just, okay, well, just let me amend that. Your registrar here, stroke that right out, amended, removed, whatever. They allow you to adjust this shit on the fly. So now again, so Bryce, you're actually showing up here with a better claim for equity, and you're showing this better claim for equity by your private appointment of new trustees expressed by a deed, absolute, and the authority made under the Trustee Act. Now, I think this is the Trustee Act for BC. Again, you're going to want to go and get the actual one, right? Where, like, I just dropped it here. It'll have, the Law and Equity Act, but this one's actually okay. So the Trustee Act, it'll have that same RSBC type number and all this other shit to go with it. Make sure you drop the proper one up there for the Trustee Act. Okay, so you're rolling through here. Number 2. Part of your statement of claim. Again, you're laying down your facts here of what's going on. What's going on right now is you're bringing a claim to do what? To quietly bring this counterclaim by petition, and again, petition's important, to apply for leave. I got to leave that other situation, whatever the hell it is you're chasing me for. I'm leaving that. I'm leaving that circus. I'm walking away. I'm leaving my person here. Boom. I'm leaving because I got to go get cleaned up. I got to get recentered. I got to get my armor on. I got to go have a little chat with our best friend Equity here. And when we come back as plaintiff, right here, we're laying some smack down. So this is where we can literally say application for leave because we got some urgent circumstances. You can probably even say right here, under urgent circumstances, and let's just do this. And taken for granted thereby. What that's saying is we know how important it is what the hell we're doing here. We know I don't have that person no more. We know for a fact that the judge cannot deny your request for leave. So because it's so absurd, I'm just going to take it for granted now, Your Honor, because I know you can't say no. You literally just kind of springboarded a little bit here. You got yourself in a better position. And what's the judge going to do? Say, oh, no, I haven't granted that yet. Okay, well, I'll wait, Your Honor. You done? Right? He can't deny this. This is a simple one. The leave is very important, though. To bring his suit properly on the equity side of the court. You only get to the equity side of the court when you've been disposed of a certain security interest to begin with. These two, see how these work together? This is what opens the door. This is what gets you in through behind the curtain. Which I was just talking about, for where the complete redress ought to issue out of chambers, given the sensitive nature of the case. That's saying, seal, please seal me. The public has no business in this matter moving forward, Your Honor. And if they don't seal it for you, ask for it. Your Honor, shouldn't we be sealing this about any time now? I'm not sure, but that's why I'm coming to you. Again, we can ask questions. Number 3, plaintiff seeks to have perfected securities paid into court, currently in possession of the court. Okay, so Bryce, as we know, last time he was in court, he literally, now I don't know if he described it or if he told the judge or the clerk, hey, it is my intent to pay this particular perfected security into court to furnish the requirements of justice. Oof. If he had said something like that, boom. No wonder the registrar responded with this. Well, Bryce, if you do this, you can't go back. This is it. Once you do this, that's it. But again, I don't know if he actually presented it to the registrar with the intent to pay it into court. He may have just said, Your Honor, clerk, here, deposit this into the court. Deposit, pay it into, very similar, but let's just clean this up a little bit, Bryce. Get this one on the record too. Get paid it into court. That's a big one. Why? Because as soon as securities are paid into court, then the judge can pay money out. That's where we're heading. That's what this is all about. So you're literally just making a statement here, Bryce. So now you could literally say, let's just say this. Securities were indeed furnished to the court on or about whenever you did it, Bryce. I don't know, right? So drop your whatever a week ago or whenever it was, then finish it with this. After you drop the 2021, always drop this one in there. In the year of our Lord. It's a big one. Okay, number 4, plaintiff. Let's switch that to petitioner. Okay, I don't even know why I got plaintiff in there. Petitioner has indeed duly authored, duly endorsed, and duly executed a personal revocable trust. As soon as the judge or the clerk sees that, they know that you know what the hell it is you're talking about. They got a lot of stuff going on here. Now this is resulting. Now the fact that you just said revocable trust that is resulting, that means that you just opened the door for the judge to now give you that constructive trust I was mentioning the other day. You show up to court and say, hey, Your Honor, I got a few things here. I don't know if this is correct. I don't know if this is all kosher. I don't know if this is all done in proper sequence. All I do know, though, is that I've got I've done this and I've done this and I've done this. So now I'm coming to you, where under all these executions and all these attempts at settling my affairs and putting the proper security interest into the possession of the proper party, again, this is all done in good faith. Now, Bryce, again, keep throwing in good faith, in good conscience, for a good reason. Throw that, sprinkle those words throughout your entire process here. The more you talk about acting in good faith, the better. Now you'll notice, loved ones, I haven't even dropped the maxim in here yet, but it's coming. Okay, so anyway, number 4, the plaintiff has got a resulting trust from his contribution. Ooh, contribution. What's the contribution? The silver coin you attach to that certificate. Remember, now let's rip right back down to legal basis where they were talking about founded on a legal right. They had the word contribution in here, did they not? Pretty sure they did. Okay, doesn't matter. I wasted enough time on that one. The contribution is huge, and they do absolutely recognize the contribution. The contribution is what unlocks. It's what literally, it's you purchasing your equitable rights back. Okay, Your Honor, I'd like to buy my rights back. And he's going to look at you and say, okay, well, how'd you like to pay for that? And if you said, well, I've got a $10 bill in my pocket. If you pull out legal tender right now, you just got bounced out of chambers. He will literally kick you out for that. That money is not allowed in there. Only come with the good stuff. Okay. Okay, so I was finishing with, okay, so his contribution as surety. Again, surety is a very important position and relies thereupon the doctrine of merger to extinguish the defeasible title in him. What does that mean? It means you're taking that person off. You're taking that defeasible title. Defeasible means it can be defeated. It means it's actually full of holes. That's the Swiss cheese title. That's the one we don't want to be in possession of. So I'm being removed, or it's literally being stripped off of me, and it's now being stuck or attached or appointed or fixed or ordered to that other party standing over there. Where subsequently, that defeasible title is vested in him, the new express trustee. Boom. Number 5, the plaintiff is without adequate remedy at law. This is a big one. This is setting the stage for, you know what? I don't want to play games in the legal at law, common law side anymore, Your Honor, because I know you can't take cognizance or you can't take recognition of any of my equitable pleadings, trusts, documents, anything I'm talking about. The maxims, you won't hear any of it. So there. Because I got a conflict with that system, that's why I got to leave it. That's why I'm making application for leave based on a few of these goodies here, Your Honor. And because of your conflict with the rules at law and given consideration of the premises, that literally means you gave. And if you gave, you're the donor. And if you're the donor, you just purchased something. You just purchased something with consideration, the real good stuff. Now, given all that, the initial process of getting this counterclaim started and filed and registered and brought to the judge immediately, all that type of preliminary process, all of that ought to issue right away, because my prayers for general and alternative relief may be heard. You can just check a period on that one if you want. Petitioner reserves any and all right, liberty, or process to amend his affidavit. Probably you want to drop there, maybe check a plural on that one. Oops. Again, I'm not being too worried about the punctuation and grammar here. Or suit as necessary. Again, you can, the courts will always operate on what's most convenient. If it's convenient for the judge to declare a constructive trust and put the proper parties in possession of the proper titles, and declare that through a decree based on the evidence brought before the court today, they will instantly grant these motions right now. That's why Bryce, I'm in like, dude, when the judge says to Bryce, what's the remedy you're praying for? I know you're not going to say, I don't know. Okay, relief sought. The petitioner prays for general relief and special relief. Again, there's two of these things going on. So anyway, the petitioner prays for general relief, given the event of his natural disposition of security interest and subsequently attaching that interest to the defendant named above to undertake, oh, there's a deadly word for them, and specifically perform, there you go, there's one of the equitable remedies right there, according to the terms of the deed, which is attached here to marked Schedule A2 or A1 or whichever. Okay, so Bryce, if you're going to roll in with your adverse claim suggesting as your Exhibit A1, roll in with your deed here as Exhibit A2. And now if you're saying, yeah, but Darren, I don't have that deed. I've got one mashed up here in the background that I could probably fire to you, and you could probably make some quick changes to it and get that brought to the judge. But you know what? You could actually say, you know what, Your Honor? I have the deed. It's mostly constructed. It's not finished yet, though. It's a working draft. To the best of my abilities, is that good enough? So, of course, he's going to say, yeah, let me see that. Let me see what you got going on there. What he's going to literally say is, yeah, Bryce, don't waste any more time you trying to do it because you're probably wasting your freaking time. I'm going to revamp. I'm going to reform. I'm going to redraft this whole thing for you anyway. So don't worry about it. Oh, okay. Thanks, Your Honor. Okay, according to the terms of the deed, and that an order issued out of this honorable court sought to issue in favor of the petitioner's requests. A certificate of acknowledgement of deposit would be nice, because I don't know if Bryce got anything when he paid or when he deposited that birth certificate with the coin and all dolled up. when he handed it to the registrar or the clerk, if he didn't get something back with a stamp on it or something back saying, yes, the court just took possession of your security on such and such a date, if you didn't get anything like that, dude, you gotta. And ask for it in the form of a certificate, please. What's the purpose of that? So that you can go to land titles and file it. There. Land titles love certificates. We always want to be dealing in certificates. Always be asking for certificates. We're going to be certifying events, and we need certificates in return. Judges love certificates. The whole system runs on it, oddly enough. Your birth certificate is a certificate, see? Okay, or receipt acknowledging or a receipt describing the securities paid into court ought to issue as reasonable. And for the sake of convenience, furnish the grounds for his petition. If the clerk or registrar did give Bryce a certificate, boom, he can actually whip it out right now. Say, look, I've got evidence that I've been disposed of that security title, that security interest, that perfected financial asset. I don't have it. And if I don't have it, that means somebody else does. And if that somebody else does, that means I'm entitled to relief. I'm entitled to all the equitable stuff I'm chasing. I'm entitled to an accounting, an injunction, the appointment of a personal representative, the appointment of a receiver manager, all that good stuff. Moving on. Number 2, petitioner also prays for special relief or alternative relief that may be seen as convenient, again, given the special life interest expressed. Boom. Once you express a life interest, now you can have a life estate granted in your favor. That's going to be part of what the judge decrees or orders for you. He will construct a life estate for you. And his adequate entitlement, he has taken for granted. Literally, you just said that you've taken your security entitlement for granted. Why? Because you granted that security interest away. We're not going to be left here with nothing. Nope. I get something back. And I know what's coming, so I can literally take it now because no man, judge or otherwise, in his or her right mind, would deny your honorable and humble requests for this stuff. Deadly. Okay, because we're taking that thing for granted and thereby requires the court a decree supporting the same. Thank you. Okay, now here's a chunk of meat right here. An interlocutory order. What is that? That is a special order that if enough evidence is brought to the judge's attention at any time in a proceeding, even right up until sentencing, an interlocutory, it's like a special lightning bolt order that the judge can exercise at his or her discretion. If enough evidence comes to her attention, they can interrupt the proceedings, grant an interlocutory order to stay everything, settle a few things. The judge can literally do this. He can grant a temporary injunction right now. He can grant or he can order a master to take those securities paid into court and go do an accounting, go sequester, go segregate, go marshal all the assets attached to that certificate. How long does that take? I don't know. I bet you they can do it pretty quick. If not, the judge might say, hey, here's a temporary bank card issued out of the court because your certificate was specially deposited in the court. Remember, the court is a bank. Absolutely it is. Remember, Chief Justice John Roberts out of the United States Supreme Court said that he is Treasury and what he's doing is none of your business. That means every courthouse is a bank. And every judge of it is a banker acting on behalf of Treasury. Depending on what you're doing, he can do some incredible magical unicorn type things for you. Legal basis. Okay, they're always going to sting us with this one. If we don't bring a solid legal basis for our claim or our argument or our statement of facts, they bounce our shit instantly. Now, this is where quoting out of the Law and Equity Act in British Columbia, like I said, This is a fantastic chunk of legislation. When I found this, I almost fell off my chair. It's the only province. Oh, sorry. I think the East Coast, one of the East Coast provinces has an act sort of similar to this, but this one's incredible. And why doesn't the rest of the provinces have this? I don't know. Something we might want to look into. Number 4. So based on this legal basis, equitable remedy sought by petitioner. How can equitable remedy be sought by the petitioner? Well, for all the shit we just did above there. And yet, okay, to be honest with you, loved ones, we laid down so much substance right here. Look how short this shit is. Are you kidding me? Where did the 40-page days go? I don't know, Dean, but you ought to be impressed here, dude. Look how short this is. Incredible stuff. You could almost memorize this shit, literally. It would take a little bit of time. Once you develop this document and you look over it enough times, now I know Bryce is always in a shotgun situation, so we like to operate in shotgun situations. What's that mean? That means Bryce is rolling into court tomorrow to deal with this. So this is why it's super beneficial now for anybody else hearing this and having this resource now for people. Anybody rolling into court in a week, well, now you've got this to work with. You got 7 more days to fine tune the shit out of this. And you know what, loved ones? If I were to go redraft this tomorrow, would it be exactly like this? No. It wouldn't. I would actually come up with other stuff to throw in here. I could actually remove some stuff, which is why we always want to reserve the right to amend our pleadings or change stuff on the fly whenever we want. We always got to be reserving that right. So back to that number 4 for our legal basis here. This one's dangerous. This one's so incredible. If a plaintiff or petitioner claims to be entitled to an equitable estate or right, well, then you know what? Look at the way they say that. If a plaintiff or petitioner claims to be entitled to an equitable estate, then you know what we should do? Let's just do this. Here, this is how slick this stuff is. And relief against a deed. Yeah, let's take all of this. Watch this. So we're going to copy this. And we're going to move it right back up to our statement of facts. As a matter of fact, we could probably even drop it into number 1, maybe even number 2. And he could literally say this. I am okay, hang on. Bryce. Now you can finish this. Middle name, right here, probably drop this. Protected purchaser for valuable consideration without notice. Yeah, that's a huge drop right there. Okay, so now that we identified who this cat is, now let's drop this. Well, we just cut it and pasted there from the other thing. I am a petitioner who claims. So let's just do this. The petitioner who claims to be entitled. There, boom. See how you literally just satisfied one of the requirements that they're asking for. How easy is that? You just took what it is they're looking for. Boom. Okay, what else are they looking for? Okay, now again, against that deed. That deed is super important. Does that perfected security certificate in registered form constitute a deed, Darren? Is that actually a deed? You know what? Given the amount of stuff we wrote on it, I would say, yeah, it actually is a deed. But the deed that we came up with, again, it's 4 pages long. It's a whole bunch of terms. It's a whole bunch of, hey, trustee, I need you to do this. And then I need you to do that. And then after a few other things, I don't even really care what you do after that. And I'm not going to even show any interest in it because it's assumed that you're going to go do it in good faith. So we don't need to go list out. We don't need to exhaust that list. We just need to get the ball rolling. Just get it started. Show up with 1, 2, or 3, or 3 or 4 things. Plenty. That's lots of substance for the judge to get rolling. For the judge to see, okay, Bryce, what's your intent here? What is it that you're actually trying to do? Well, Your Honor, I attempted to protect my God-given rights through posterity by attaching valuable consideration to a something over here. And then I expressed a trust around it. And then I formulated a deed. And I'm bringing all that under an affidavit to your attention today, Your Honor, so that we can revest that particular security interest into new trustees, the proper party. Oh, okay, well, yeah. Okay, Bryce, I think I can help you with that. Again, there's probably a million different combinations of what I just said there. Something like that. Again, you don't need to use all these Darren words. Remember, the judges are looking for clarity here, not fancy language, not the technical red shit that I'm always talking about. Okay, again, I just love this number 4, so I'm going to continue. So we got a deed, an instrument, or a contract, or against any right, title, or claim asserted by a defendant or a respondent in a cause or matter. So that's you. Remember, you and the defendant, you were the defendant in the other cause, remember, where they couldn't hear any of your equities? Well, you're kind of just referring to that right there. Where I was a defendant over there, Your Honor, and I know you can't take notice of my equitable estate. You're just going to ignore it. Well, I don't want to play there. That's a shitty sandbox. It sucks. I want to move my claim to the proper jurisdiction, Your Honor. Great. Okay, so then we're talking about to get the relief founded on a legal right that before April, a long time ago, could only have been given by the court as a court of equity. So boom, when you have clerks and registrars and people saying, oh, there's no such thing as a court of equity. Really? That's not what number 4 is saying. Number 4 is actually saying the direct opposite. I claim the complete contrary to be true. Well, that's a pretty mighty claim you just made there. And that either as a court of law or equity, and every judge of it must give the petitioner the relief that ought to have been given by a court in a suit or proceeding in equity for the same or similar purpose properly commenced before April 29, a long time ago. That's saying, hey, as long as you bring the subject matter, or as long as you bring your case sort of properly, like we used to do it 150 odd years ago, then the judge will actually roll in, act on his discretion, and grant you that equitable relief that you're seeking. So Bryce, yeah, man, go ahead, fire in section 34 here. Same idea, same style. Now I'm going to suggest this. In one of these statements, let's say something to this effect. Let's just drop it in 4. Okay. Petitioner knows the above equities to exist. The petitioner, claims. Okay, do you want to use claims or adverse claims here? I don't know. Use both. Watch this. Petitioner adverse claims. Claims. See, just fix it. Both. There. Whatever. We know an adverse claim is this very specific claim attached to a financial asset. Who's holding that financial asset? The judge. And again, this is where we want to use the originals, loved ones. Do not roll into this situation in court and go to present the judge with a photocopy. No. Fire the original to him right now. Just get that out of your possession. Where was I? Okay. The petitioner adverse claims or claims the above equities are the petitioner claims the above equities are just, and the petitioner claims said equities. Now, because we see how we rolled through this 3 times, I kind of talked about the same thing 3 times here. The petitioner's claiming that this thing's here. I'm claiming it's just, I'm claiming it's right, I'm claiming it's legit, and now I'm claiming both of those to be my equities. So Bryce, I'm going to go back into my documents because I know I didn't finish this one quite right. My other styling is slightly better than this, But for this portion of the segment here of what we're trying to lay down, this technically would get the job done. But just give me another, once I'm off this call, I'll go back, I'll find that exact thing, and then we'll just insert it here, okay? Because that's, when you're suggesting something exists, when you had a hand in its creation, and then you're suggesting it's bona fide, and then you're claiming that all this is yours, that 1, 2, 3 punch is deadly. Super, super important. Again here, plaintiff is without adequate remedy at law, and thereupon having regard to his conflict with the rules at law, and given consideration of the premises. Remember, what's the consideration of the premises? The fact that you've parted ways with that certificate, the fact that you've parted with consideration, you're actually out 1 silver coin. You're $28 poorer than you were an hour ago. The fact that you've parted with something of value means that somebody knows you something. You literally took something valuable and you attached it. I don't want to say contract, but you attached it to an agreement. That value made that agreement valuable. Pretty cut and dry. Now, again, remember, the petitioner reserves any and all right, liberty, or process to amend his affidavits or suit as necessary in order to avail himself in the future respecting the above. Again, look how short all this stuff is. Relief sought. Just talked about that one. Again, we got special, we got general relief. We've got 2 different kinds of relief here. One of these processes is extraordinary. It's all the equitable stuff that they never talk about on the public side. So you're going to get all the public relief that you would normally get, and then you're going to get all the equitable stuff as well. That's why praying for each relief is important. Again, we just mentioned the interlocutory order. This is an order that the judge can make at his or her discretion right in the middle of a case, depending on the evidence brought to his or her attention. When you start talking about some of the evidence that we're talking about, he's going to have the ability to stop that other proceeding that you're trying to defend yourself from. See why this is such a better loaded scenario. Trying to get all these equities down as a defendant can be done, but trust me, this is just a way quicker, way easier, because now the judge is going to look at your claim and their claim equally. There's 2 claims before the judge. Which one has more merit? Which one has more substance? Which one has better claims for equity? Which one has a better title attached to it? Yada, 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 and so on. So again, Bryce, yeah, man, this is one of my favorite ones, number 4 out of the Law and Equity Act as the legal basis for your claim. You're asking that your equitable reliefs be granted. That alone, this is probably, again, as I said earlier, this is probably the only one you need to get the job done. This one's literally that powerful, loved ones. And then, like I said, dude, go ahead and fire in section 34, because again, it is, that 34 is another dynamite one. See, this is where I used to get just ridiculously over the top with these. What I used to do, loved ones, I would go to this British Columbia Law and Equity Act, and I would pull out 40 of these things. Literally, like, oh my God, Judicial Notice of Equitable Estates, number 7. That one is also so important, Your Honor. How could I not include that? I would literally put that one in my legal basis for my claim. Can you imagine having 40 legal bases for your claim? So overkill. The judge doesn't need to see you itemizing all 40 of these things. Pick a couple. Pick 1, 2, or 3. Again, 3 is a good number too, Bryce. Whatever you want to fire in there, dude. Number 34, again, this is another favorite. Surety who discharges liability is entitled to assignment of securities. Oh. If I had to pick a third one and fire it in there, that's what I would pick. These 3, if you put 1, 2, 3 of those together as a legal basis, the judge is going to have a pretty tough time not granting it is what you're seeking. Now, remember, Bryce, what is it you want right now? I don't care what your situation was. Whatever it was, Your Honor, we're motioning for leave. I want to leave that suit. I want to leave that scenario, leave that predicament so that I can get my hands clean and come show you, Your Honor, my own suit, my own claim with proper equities behind it. If we don't ask for leave, we're stuck in the military base. Really, really important. That's why it's in the top 2 things that we're asking for. Now, okay, for relief sought, I'm going to throw one more in here. Petitioner also prays for special relief. Okay, so all I would add in here is, what is it that we're praying for? What is the alternative or the special relief that we're praying for? Let's just do it right here. Let's just go A. Let's go injunction. Let's go B. Counting. Let's try, what am I on, C or B? C. C. What do we want after an injunction and accounting? We want the appointment of receiver manager. If I had to pray for a fourth thing, what would it be? D. Who knows this one? Appointment of new trustee. Yeah. Appointment of a personal representative. Yep. So let's just fire that one in here. See, now I'm going to change this. Okay, appointment of a trustee is what we want. Yes, but you know what? You did it already. You can appoint trustees two ways. You create your private agreement and appoint a trustee right there. And if they laugh at you and say, "Ha ha, you're on crack." Well, okay, here, Your Honor. You take a look at this. Now I require the court to appoint a trustee. Boom, it's one of the two. Start with privately appointing your own because it's fun. Once you get good at doing this, you can start to appoint trustees all over the place. And this starts to come in very handy if you want to do big things in the world. And they're only going to laugh at this once, because when you go bring a claim like this to the court, hey, Your Honor, that lawyer over there, he laughed at me and called me a jerk when I tried to appoint him a trustee. So I need you to second that motion, please. Boom. That's essentially all that's happening here, loved ones in the background. Okay, point. No. So let's say acknowledge. There we go. Acknowledge the private appointment of new trustees. Simple. And okay, I'm on E, right? E. Let's throw in appointment of a personal representative right here. I don't even know if I'm spelling this shit right. I'm just kind of winging it. Rev. There. That. Good enough. That may be seen as convenient. Yeah, all that is convenient. That's going to streamline the shit out of everything. You know exactly what it is you're talking about, or what you're after. Now, remember, as I was suggesting earlier, when we ask for an injunction and accounting and all those appointments, those are the equitable reliefs. The at-law side doesn't like that. So the at-law side is going to say, okay, we see what it is you're after, but instead, we're going to declare your priority. We're going to declare your title. Once you have that declared title, once you have, hey, Sally Sue does have priority entitlement respecting this particular life estate. She can do this. She has incredible powers. She can do a whole bunch of stuff. Again, now we want to take that order, that decree, and we go register or record it at land titles. But we're literally going to tell the judge, hey, you know what, Your Honor, I got important shit to do. I don't have time to go do that. Can you get the trustees to go do that for me? In the best interests of the trust? Of course they will. It's the trustee's job to defend the trust from any and all proceedings at law. That means everything. When a cop tries to write you a ticket, he just ran into your personal representative. And Mr. Officer had to turn around with his tail between his legs and go the other direction. Okay, so Bryce, again, it doesn't matter what you're supposed to be appearing for tomorrow. I want you to file this anyway. Get this in there. How do you want to pay for this? If you had the ability to call the courthouse first thing in the morning and say, hey, I'm heading down there. I'm supposed to be in court in an hour. However, I'm filing my counterclaim. I would like to pay by a money order. What is, hey, clerk, how much does it cost to file a counterclaim? Well, that'll be $107, please, plus tax paid to the Minister of Finance. Great, Bryce, rip to the post office in the morning, see if you can get a money order punched up in that for that. Now, remember, who's the sender or who's the maker of the money order? Don't you dare put Bryce Boyden, your first and last name, on the maker of that money order. Put Bryce-grantor. Put Bryce-security entitlement holder. I don't think that'll all fit there. I don't know, whatever. Try something, but don't you dare put your surname on that one. If you do, you're literally playing with the legal game, the legal tender by doing that. We're trying to remove the surname from our state of affairs. So anyway, roll in tomorrow, get this filed. What this is going to do is set the stage to crush. I believe you have that other thing coming up on the 24th-ish, I think. 16th? Okay, whatever. So yeah, this is going to crush that. This gets the door open so that you can start getting your equities heard. This opens the door for you to be compensated. Remember, we're vesting interests here, Your Honor. I'm divesting. I'm revesting. Your Honor, we're seeking a vesting order from the court. Maybe you can even throw that one in there, Bryce. I require leave from the at-law side to pursue a vesting order on the equity side, Your Honor. I don't know, there's another statement of interest. However you want to flavor this. But again, there is a lot of meat in how many pages have we got here? Just really look at this. Does this amount of text actually add up to, okay, we might be at about a page, right about here-ish. Okay. I'm going to throw it out there, Bryce. We're at about a page and a half. If you literally had to just add up all these paragraphs and style it onto one document, literally, we're at a page and a half. Now, Bryce, you're sitting in an awesome position because you've already paid that security into court. Dude, you're so far ahead right now, it's unbelievable. You just get recognition of that. Get a certificate outputted from that. Hey, clerk, last time you never gave me a certificate evidencing a receipt of that transaction. I need a receipt, please. I need a certificate, please, issued under your hand so that I can go record it at land titles. Oh, okay, yeah. Here's the stupid thing. If we don't ask for this stuff, they don't volunteer it. They just sit there and say, oh, I wonder if he's going to ask me for a certificate. Nope. He's gathering his papers. No, he just stuck his papers in his briefcase. Nope, he's turning around. He's walking away. Okay. He's not interested in a certificate. See, that's how they play. If you don't know what the hell it is that we're asking for, they're not there to fill in the blanks. That's why all this shit is so important, that we go through all these procedures and we start to understand all this stuff. I know it's a big headache and a pain in the ass, but there we go. So get that cleaned up, dude. Now, again, in somewhere in here, and probably in your statement, you're going to want to add something like this. Given the nature of the case, and let's just do it right here. As supported by, if you want to put my, whatever, his, if you want to go special affidavit made on or about such and such date. Whenever you cranked out those affidavits from before. So what he's suggesting, or what you're about to do here, is you've literally now attached your affidavits from that other case to this one. Because I know you got a lot of substance in those affidavits and you've already handwritten them all out. They're all pretty. Okay, I'm going to throw it out there. Are they 100%? No, I bet you they're off the top of my head. I know we did that, 6-8 months ago. I'm going to say they're 70%. I would improve the shit out of it if I had to do it again. But they're good enough to get the ball rolling for what it is you need to do. If the judge requires anything else of you, and Your Honor, it is my intention to do anything the court asks of me, so I may do my duty to fulfill any obligation equity requires of me. Thank you, Your Honor.
Few loved ones want some clarity around how to put your name for the money order.
How to put your name for the money order. Okay, $107 made payable to the Minister of Finance. Subject, put your court case right there. File number, drop that court case right there. If you have the room to add in trust, if you can put court file number in trust, if you can get that on the subject line of the money order, man, are you laughing? And then the name of who's making this money order. Bryce Grantor. Bryce, middle name, Grantor. Good enough. Do you want to put Bryce in all capital letters or style it properly? No, I'm going to suggest style it properly. Capital B, small r, small y, small c, small e. And when the clerk or when the gal at the post office says, I can't do lowercase letters there, you can say, oh, yes, you can. Absolutely, you can. I have money orders with it, but they never get asked to do that, which is why some of them are like, I can't. Oh, I didn't know I could do that. Yes, please just try adjusting the font, move the style of the text. Please, I know you can do it.
Bryce Lauren, all lowercase.
Yeah, Bryce Lauren hyphen Grantor. Or you know what? Instead of Grantor, even put Settlor there. Settlor works just as good. Capital S, Ettlor. That's you acting in that proper capacity. We can prove we were the grantee. We can already prove that, so we don't need to talk about the grantee here. That's been and done that. We got some substance there, Your Honor, that can prove such things. That's why Bryce is now in the position to settle. So what's this doing when you create this money order this way? Again, you're actually paying for this court case with silver-backed money, not legal tender. That's the whole purpose of paying with a money order. You literally pay a conversion fee of $7 or $9, whatever it is nowadays, to convert legal tender into equitable money. The real deal. That's why they charge you this little fee. Okay. Anything else, Rahan? That's it for questions? Okay, I know we got lots. We can probably just kick this off. Let Bryce, you go tear through that for an hour, buddy, or two, whatever it takes. I think it's 9:30 your time, so I know you're a night owl. So I'm going to stay up for a couple more hours yet anyway, and I'll keep tabs on things, and we'll fine tune a few more things. Take snaps of the stuff as you print it. If you're able to print it tonight, shoot it up on the Telegram chat there, the Divergence Live one again, and let us know, and I'll keep tabs on this for the next hour or two. Failing that, I'll be up again early tomorrow. We can go over this again and just, any last minute things you need to do. Again, the fact that you can add and amend your pleadings at any time, you've reserved that right. Technically, dude, you can literally, with a red pen, change any of this. And as long as you initial it as you go, the clerks / registrars let us do that. So I think I was on these pages long enough for everybody to get a quick sniff and a quick snap with their phone, getting some images down so that they can see what's going on here. Again, so Bryce, see what you can do. I'm actually going to piss around with this too to see what I have to push here to get where your address shows up. Also, okay, so when you push on this, alternative name. Oh, look at that. You can even fire an alternative name down there if you want. Interesting.
Darren, can you also share the legislation that you were looking at, just because we can't see it right now?
Okay, yeah, Jody's going to do that. I get to check out for a moment because that's beyond my skill capabilities. Hang on, loved ones. Okay, so you can all see this. No, okay, I gotta make this smaller. How do I make this image smaller? Show a small active speaker video. Does that make this small?
Just close this one.
Or I can just close this one here. How do I do that? Oh, just by clicking this one. All right. Oh, no. Do you want to save your changes? Sure. It's still there. Oh, it's gone. Okay. Now, I think I dragged it. Oh, yeah. Let's see if I do this right. Oh, yeah. Let me go. Okay. Law and Equity Act, British Columbia. Here, I'll just get the screen for a second. If you want to, again, take your images or whatever. There is so much meat here, loved ones. Again, this is one of my favorite pieces of stuff to come out of the legal side of things. Okay, so I'm at 26. Okay. There's that one. Execution of instruments by order of the court. Yes. Execute the instrument, Your Honor. Boom. Applicant for injunction to furnish security. Boom. You must furnish security to get the injunction. Ta-da. See how they actually just give it to you right there, but backwards, so you don't really see it. Crazy, right? Okay, I think 52. Scroll up a bit more. Recovery of property, again, that's a huge one. Enforceability of contracts, again, you could literally suggest that the deed is a contract, so that's why we want to enforce this. Receivers and managers, huge. Okay, so I'll just kind of let you see, take some images of these if you want. Oh, hang on, we'll get this thing this big in the way. Aha, I think that worked. They don't see any of this? Aha. I don't know why I'm worried about it then. Okay. 6 is repealed here, so don't worry about that. Look at that one. Judicial notice of equitable estates. Equitable waste. And what is equitable waste? Look at this. An estate for life without impeachment of waste. And the estate for life. Good thing we're looking for a life estate, right? That's what the judge is going to construct. When he creates this constructive trust, that's technically the life estate. We got a life tenant and we got a life estate. Between the two parties going on here, one of these guys is technically the life tenant of a life estate, and then the other guy has the smaller interest in the life estate. That's the trustees, that's the servants. Doing all this stuff for us. Merger, again, colleague in the United States who helped one guy get through the Stargate. The first thing he said after he went through, and this is the guy that liquefied his estate, told a third party friend, hey, tell buddy, thanks for teaching me about merger. So when I hear that, that means we really got to focus on this one. Because we're talking about an estate and the beneficial interest in it, which would not be deemed to be merged or extinguished in equity. There is no merger by operation of law only. So they're talking about some operation of law here, and then we're talking about some equity over here. So between the two, that's how the merger happens. Mergers do not happen only in the common law side. Impossible. Doesn't work. Okay, moving on. Agreements for sale. This is all pretty good stuff. Again, foreclosure. We got redemption in here. Redemption really means the payment, fulfillment, or performance by the purchaser or person claiming through the purchaser of all obligations secured by the birth certificate. And if there has been a breach of the contract or the deed or the trust of the purchaser or person claiming through the purchaser by payment of, okay, it goes on. All I'm saying here is that there's lots of good meat in here. Order for foreclosure. Power of the court to discharge mortgagor on payment of mortgage money. You know what you did when you took that silver coin and you attached it to the birth certificate? You paid that mortgage. Now you're entitled to be discharged of all those other public legal duties. Pretty good stuff. Payment of interest after default, sort of important. Costs, yeah, the judge is going to worry about all that stuff. Venue for foreclosing, we got more foreclosure, more mortgage stuff going on here. Right of redemption controverted. This is an interesting one when you read it. It's talking about the subrogation stuff. Covenants to insure against fire. Okay, well, this is if you're actually talking about a house as property or a building, right, that can catch on fire. Not saying that you can't catch on fire. I guess that's a possibility. Relief against penalties and forfeitures. Number 24, that's a huge one. Acceleration provisions. This is where the banks are allowed to accelerate things and speed up the process when they're coming after you to take your house back. So we actually get to play with acceleration clauses against them as well. Relief to be recorded. So they're suggesting here that they're going to record. Notice how this says record and not registered. Record the relief granted. It's important. Single relief on covenant. Again, a covenant is just another heavy duty type of promises set up in the deed. The deed is actually talking about covenants between the trustee and the trustor. That's actually a thing. Assignment of personality. That's that birth certificate getting assigned to another party. We don't really got to worry about damages at sea anymore because we're kind of getting around that. We're not going to get into collisions anymore because we're actually doing this stuff properly. Custody of infants. Okay. In questions relating to the custody and education of infants, the rules of equity prevail. All right. Surety who discharges liability entitled to assignment of securities. Loved ones, that is what we're doing. We know we're the surety already. We're discharging an obligation that's attached to us because we're paying for a new life. So now I'm discharged of the old life. And now we're actually going to charge this new life. This is why when Dean used to be all excited about attaching liens to everything, that a lien is essentially a charge. A lien is a charge on property. That lien literally sticks to the property. Now nobody else can play with the property because there's something attached to it. Writ of execution to bind goods. Writs of execution are very nice. Writs of all kinds are very nice. They're very equitable. Assignment of debts and choses in action. Yeah, we're assigning a debt. That's a big one. Vesting orders. Really? Yes, please. We were just talking about that. Vest the security interest in the new trustees. Revest the equitable entitlement in this guy or Bryce tomorrow. Execution of instruments by order of the court. Yep. Injunction or mandamus. Again, injunction may be granted or a receiver appointed by interlocutory order. Oh, good thing we were asking for the interlocutory order. And what was it? Our number 3 in our statement above in our court document. Yeah, we'll take that. Don't worry about the railway stuff. Applicant, Bryce. Hey, Bryce, you're supposed to furnish security to get your injunction. Did you do that? Uh-huh. If rules of equity and law conflict, equity prevails. Yeah, I got a conflict with the rules of that law. I can't hear any of the shit I'm doing over here in equity. Pretty simple. Uncertain terms and specified leases. We don't need to get into leases a whole lot. Equity kind of, equity's a little iffy on leases. Charitable trusts. Yeah, okay, we can get into that later. We got a couple repealed things. Interests of child. Proceedings and order against one of several joint persons liable. This is getting into spousal stuff, although keep in mind here, when you've been acting as persons your whole life, you're literally severing that. You're severing a joint liability. You're severing joint liability and you're giving it now back to them. Severing is pretty important. Conditions precedent. They're talking about performance of a contract or the deeds, things of this. Art, well, we're not really dealing with a lot of art tomorrow. Discount rates, future damages, kind of legal stuff. Recovery of property, and an action for the recovery of specific property. That's why you'll always see me referring to stuff as specifically and particularly and peculiarly. How do you even say that word? Peculiarly. Anyway. Moving on. Warrants. Again, we don't really need to get into warrants. Warranting. Warranties are applicable to deeds. After we create this thing, guess what? There's a warranty around this deed. It's like if you take your deed out for a test drive and you blow a tire and you hit the ditch, a tow truck's going to come because it's under warranty and they're going to replace your tire and they're going to make sure you're safe. I shit you not. Enforceability of contracts. Oh, look at this one. In this section, disposition does not include the creation, assignment, or renunciation of an interest under a trust. Really? A disposition does not include this. Interesting. But this section does not apply to, again, this is where see, they're not liking leases. They're talking about land deals, guarantee or indemnity, things of this nature. So, enforceability of a contract. What if that said enforceability of a deed? Because remember, a deed is a little bit different than a contract. So what they're actually telling you here, this is how slippery equity is. So dispositions cannot be enforced under contracts. Why? Because in contracts, you got no freaking equitable right to be doing nothing. You can't even create a trust, right? When you're walking around in person. So that's how sneaky they are with telling us this shit backwards. We're just about done. Spousal capacity. Okay, if you got a beef with your wife or your ex-husband, if whatever, deal with that. Electing party, notice of protest. Yeah, we don't really need to get into notices of protest. We don't protest. Protests are kind of, what's the word? Not war-like, but they're not really in peace. Receivers and managers are important. Yes, we're good. Definitely interested in receivers and managers. And that's it. That's that whole thing. Now, me scrolling through this, if I did a shitty job and you weren't able to screenshot it as you would have liked, again, just hit up the British Columbia Law and Equity Act. If you want to have a reference, start looking for some of these things in some of the legislation near you. If you can't find it, that's okay. There's always going to be a provision for an injunction that may be granted or a receiver appointed. That could be under the Land Titles Act. That could be under the Personal Property Security Act. That will be found somewhere in your neck of the woods. Again, we just got to do a little bit of digging here. We've done a lot of digging for a lot of this stuff in the past, for England, Australia, things of this nature. But at least now you have a good little guide as to what it is we're specifically looking for. Again, bring this, loved ones, as a new claim. Bring it as a cross claim or a counter claim, whichever. This serves both purposes. If you don't have an existing claim that you're fighting, start your own by doing something like this. Get those securities in the hands of the court and get some of this stuff rocking and rolling for you in the background. You'll be shocked at how fast you can get some stuff rolling in your favor. Okay, loved ones, I think that'll do it for about now. Like I said, I'm going to stay up for another hour or two picking away at this. We're going to rock and roll. Touch base again first thing in the morning. Sometimes, I think Bryce is going to court. Yeah, I think they like to start proceedings at, 9:45? 9:30? I don't know, somewhere in there. That probably gives Bryce a little bit of running around time in the morning to hit up the post office because I think they open at 9. I don't know. I haven't been to one for a while. But you probably have just enough room, Bryce, to squeak that in and get that done. Worst case scenario, if you can't get the money order pulled off, pay for it any other way, whatever. That's not going to wreck our process here. All I'm suggesting was that if you did have the time, that money order puts a nice little spin on it in your favor. All right, dude? So, yeah. Okay, here's the other thing we're going to start doing. These little Zoom meetings, these are actually going to be pretty effective. We have a lot of loved ones that are in other parts of the world that really hate getting up at 3 a.m. to listen to this shit. So I'm going to start blasting one off at like noon my time, and then another one at 7 or 8 my time. So we can literally have almost a real-time thing going here where when I post up a 1 hour thing or a 1 hour shot just like this, by the time we upload it, it gets sent all around. You all watch it for an hour, develop your questions, feedback from it. I can develop the next hour in the later segment in the day. So we can literally just be rolling this thing through in real time now. And again, we're going to start branching off into all kinds of directions. Again, I'm only dealing with Bryce's situation, but you can see here, loved ones, how Bryce's situation is very compatible with everybody else's. We've all got the same problem. We've all got the same conflict with the rules at law. We're all trying to negotiate the certificate the same way. And again, hats off to Bryce for finally having the balls to roll into court and produce and furnish that birth certificate with the coin attached to it to get that clerk to say something to this effect. You know, once you do this, there's no going back. That was like Christmas Day for me when I heard that. That's how close we are. Okay, loved ones, we're going to check out and we'll check back in a little bit. All right. Peace.